second issue reported by this Hindu, which is, I think, is a constitutional relevance, is this news that Central notified appointment of 8 new judges, new High Court judges. So 4 years after collegium advice, a lawyer named JK additional Jammu and Kashmir additional judge, that is Wasim Sadiq Nyargal. So he was appointed as an additional judge of the Jammu and Kashmir after 4 years, 4 years after the recommendation of the college. So we are looking into whether that appointment is a fair after 4 years is a very important question. So we just gone through the history of the appointment of constitutional court judges in India and the independence of judiciary. Because from 1950 to 1973, there was a consensus between the government of the day and the Chief Justice of India on the appointment of constitutional court judges. That was the position. There was also a convention that the senior most judge of the Supreme Court was appointed as a Chief Justice of India. And in 1973, that year was very important, that A.N. Roy was appointed as a Chief Justice of India by superseding the 3 senior most judges of the Supreme Court. This resulted in a clash between the executive and the judiciary in the appointment of judges of our constitutional court. So the first judge's case was reported in 1982, and the case was popularly known as S.P. Gupta versus Union of India. And in that particular case, 7 judge benches by 4-3 majority held that in the case of appointment of a judge of the Constitutional Court, the president has been bound to make a decision based on the consultation of the Supreme Court. So that consultation is not a strict or mandatory requirement for the appointment of a judge. So in this particular case, ball was in the court of the executive, because the executive have more wisdom for the appointment of the judges of the Constitutional Court. So then in that time, the most important question was if it is violating the independence of judiciary. So there was a debate on that particular issue even after the first judge case, the S.P. Gupta versus Union of India. And in the second judge's case in 1993, that case was popularly known as the Supreme Court Advocates on Records Association versus Union of India. This case was decided by 9 judge benches, overruling its earlier judgment, the S.P. Gupta versus Union of India. And in this particular case, the court held that effective consultation, that is the most important point, effective consultation is a requirement for the appointment of Supreme Court and High Court judges. And the collegium system was also adopted in this particular case, and the Chief Justice and 2 senior most judges were the part of the collegium system. And in the third judge case, that was in 1998, it was a presidential reference under Article 143 of the Constitution. And it was a reference made by then the President of India, K.R. Narayanan. And that the main point of that reference is regarding the meaning of effective consultation, which is relevant under Article 124, Article 217, Article 222 of the Indian Constitution, especially related to the appointment of the Supreme Court and High Court judges are concerned. And I already mentioned some of the most important articles which deals with the appointment of the Supreme Court and High Court judges are concerned, and independence of judiciary is concerned, because Article 50 of the Constitution deals with independence of judiciary, and Article 124 clause 2 and 4 deals with the appointment and demand of removal of the judges, and also Article 214 the High Court, and Article 216 the composition of the judges of the High Court, and Article 217 the appointment of the High Court judges. But the most important point decided by the court in the third judge case, that is in 1998, is that they accepted the collegium system, and they expanded from the collegium system from 3 judges to 5 judges. And the effective consultation is a mandatory requirement. It is a conditional precedent for the appointment of a judge. So here, then what happened during the last 2 decades? Because in the last 2 decades, collegium system faced a lot of criticism. Collegium system faced a lot of criticism, and not only from the government, but also from civil society, due to its lack of transparency and accountability. And as a result, National Judicial Appointment Commission Act 2014 and the Constitutional 99th Amendment came into force. And in Supreme Court Advocates on Records Association versus Association and Others versus Union of India case, as you're well aware of the case, in that particular case, they declared, the Supreme Court itself declared that this National Judicial Appointment Commission Act 2014 and the 99th Constitutional Amendment are unconstitutional, because of the reason that it affects the rule of law and independence of judiciary. And they restored the previous position, that is a third judge's case, which was a presidential reference made in 1998. And where the decision of the Supreme Court was the collegium, the decision of the collegium is binding to the government. So there is but in this particular case, there is a 4-year delay in was a serious concern of rule of law and the independence of judiciary. So that is I think, which is very important decision, important news, and it has some constitutional perspective, because independence of judiciary is one of the basic structure of Indian Constitution. So the third important issue that was reported by the Hindu newspaper is also a very serious human rights issue, that Kashmiri Pandit, Valley, and 2 dead in fresh targeted killing in Valley, and the government was not willing for relocation of the Pandit from Valley. Horrible incidents was happened after a couple of days. The government decided to post Pandit teachers in a safe zone within the valley. So this particular case, 9 people lost their life. 9 people lost their life in the horrible incident, and it also this incident is itself put forward certain constitutional question in front of us, especially those fundamental rights issue, because there is a serious violation of fundamental rights, especially Article 19 and 21 and Article 29 of the Constitution, especially Article 19 clause 1 to 19 clause G of the Constitution: freedom of speech and expression, freedom to settle, freedom of profession, life and liberty and dignity of individual guaranteed under Article 21 of the Constitution, and also the minority right guaranteed under Article 29 of the Constitution. So I think those people 9 people, those who lost their life, the legal representative can file a writ petition for compensation, because life under Article 21 includes right to compensation. So it is the duty of the state, as you know, that it is a general principle, it is a well-known principle, that it is constitutional principle, that it is the duty of the state is to protect the life and property of the people. So if there is a failure on the part of the state, whatever reason, it is not justifiable. So I think this news is a very important news. And the fourth news reported, I think it is very relevant, is a Manoj versus State of Madhya Pradesh case, which was reported by the Supreme Court in May 2022. And there was an editorial, the challenges of reforming death penalty sentencing, which was written by CP Sruthi and Shivani Misra, National Law University, Delhi. They are with the Project 39A, a pro bono legal aid project. Project 39A represented the appellant in Manoj versus State of MP. So this particular news, the editorial, I think it is very important in the constitutional jurisprudence perspective, because in this case, the Supreme Court asked Attorney General, K.K. Venugopal for assistance to institutionalize a mechanism by which transform crucial to decide whether a person should be condemned to death or not can be gathered and placed on record before trial judges. So in this case, the Supreme Court held that this one size fit all, one size, they use the word one size fit all approach will considering while considering mitigating factors during sentences should end. So this one size fit all, we should abolish this one size fit all for all cases. So the court also mentioned about the mitigation expert. So that is very important. Mitigation expert, a qualified professional in underhidden access to the convict past ought to be at the center of this change in outlook. So the mitigating expert and the mitigating investigator would be expert. So who is a mitigating investigator? Mitigating investigator would be an expert in fields of varied as social work, sociology, anthropology, criminology, psychology, and other social sciences. And they should interview convicts, their family, friends, and other associated with the prisoners and their past to draw a complete picture. The information should be placed before the trial judges. So I think this is a very important step, reformative step in the criminal administration of justice system in India, because the content of the editorial was that the lower court must comply with the Supreme Court decision in Manoj Vais's state of MP, enabling an informed sentencing inquiry. That is a very important thing. That informed sentencing inquiry, that is a very essential requirement, and not one size fit all policy that is justiciable, because that policy is not good. That was the findings of the judgment Manoj Vais's state of MP. So the proper implementation of Manoj's judgment will bring fairness in criminal administration of justice and will ensure constitutional vision of justice enshrined in Article 14 and Article 21 of the Constitution. So we are second last topic that was, I think it was also very relevant because of time constraint. I only selected 6 topics, and I think I will explain some of other topics after this presentation. But I think almost 15-20 important matters are there in the June edition, because a lot of issues involved so many constitutional human rights issues. But the 5th news that I found very relevant was a doctor filed seeking category for casteless Hindu. So this is a very important thing. This because this caste system in Hindu religion does not. This is the case which is pending before the Supreme Court. So why this is very important in the constitutional perspective is that this caste system in Hindu religion does not satisfy the constitutional standard of equality and fairness, because it creates a hierarchy. It creates a hierarchy and claim superiority, and to treat fellow human being inferior and unequal. So this is what is actually the findings of the Dr. Ambedkar in his book Annihilation of Caste. It should be abolished. That was the dream of Dr. B.R. Ambedkar, that the father of Indian Constitution. He did mention the evil impact of caste system and its importance of annihilation of caste. And we need a religion which treats as liberty, equality, and fraternity, as mentioned by Dr. Ambedkar. Therefore, a casteless Hindu designation will definitely a welcome step that will lead the reformative Hindu religious order. So I think which is a very important thing, which because as you know that even though the constitution tried to abolish the all kind of religious and caste discrimination, but at the same time the caste discriminations are still prevailing in many part of India. That is the reason why this kind of because in as you know that this book is a very important book that every law student must read. Annihilation of Caste, where the Ambedkar said, because this book was written in 1935, which is available online, and even you will get a soft copy online without any fee, without any cost. So, but at the same time, he said intermarriages, interreligious, intercaste marriage is one of the solution for annihilation of caste. I think another important solution is this writ petition filed before the Supreme Court, casteless Hindu. So if this petition is allowed, then we can reduce the caste superiority division in the Hindu religious order. And this is the last topic that the Kerala High Court stayed sedition case against Aisha Sultana. So, as you know, that Aisha Sultana was charged in sedition, especially the Lakshadweep agitations against the government, because of so many human rights violations were happened in Lakshadweep, and Aisha Sultana was also fought for human rights. And the government charged against sedition. So, you know that Section 124 capital A of Indian Penal Code is in suspended animation because of the recent judgment of the Honorable Supreme Court. And as you know that, which is actually a very welcome step. And I already mentioned in our previous class also, that because it was also reported, it was happened in May. So in June month, this news was reported in Hindu that the Kerala High Court stayed sedition cases against Aisha Sultana. So normally what Supreme Court did in its past decisions, the Supreme Court set aside, that is a very important thing, set aside a law which was declared unconstitutional. Because of the reason that it is violative of Part 3 of the Constitution. But in this present case, the Supreme Court suspended. The Supreme Court, that is a very important. Supreme Court suspended Section 124 capital A in its operation and directed the central government to revisit Section 124 capital A of Indian Penal Code in the light of the Kedarnath judgment and also the other fundamental principles of the Indian Constitution. So this provision, in fact, a grave and intolerable threat to our republic. And the same law that was used against our freedom fighters and the principles of law that suppressed liberty as mentioned by Gandhi in his sedition trial in 1922. And it was an unruly crime with a dangerous essence. That was the statement of Dr. G. Mohan Gopal, former director of National Judicial Academy, Bhopal, and also data shows that this provision is arbitrarily used as a weapon against the citizen for their dislike and disagreement with the state. So all arrests recorded under this section 124A, if it did not satisfy the Kedarnath judgment guidelines, then it will lead to a lot of human rights violations of Indian citizens, and they are entitled to compensation. I already mentioned that they are entitled to compensation for constitutional tort, and because this section was abolished in United Kingdom in 2009. So the immediate repeal of this provision is an essential for our constitutional fairness and the rule of law. Thank you very much. Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional